Talking about the second aspect which we are going to discuss today, that is a concept which frequently keeps coming up these days in the context of payment of rent. So many a times the questions come up is whether because of the lockdown where a licensee or a lessee has not been able to occupy his premises, his business premises, there's a complete lockdown, will he be obliged to continue to pay rent during this period? And the legal answer to that question is to first look at your contract, your lease agreement or your leave and license agreement, to see if there is a force majeure clause. If there is a force majeure clause in your contract which provides for suspension of obligations of payment of rent, or which provides for deferment of payment of rent, or which provides that if a premises is not occupied for 15 days or 30 days or 45 days, you can terminate your contract. In such a case, the remedy of force majeure will be enforced, and you will be right and correct to withhold payment of rent as a result of this pandemic, which, if it qualifies within the terms of the force majeure clause in your rent agreement. Now, what happens if you do not have a force majeure clause in your rent agreement? In such a case, a doctrine of frustration, it has been held, will not apply to a lease, because lease is covered under the Transfer of Property Act. And here, there is a concept under Section 108, which in that sense is quite akin to Section 56 of the Contract Act. Under Section 108 of the Transfer of Property Act, a lessee can put an end to a contract of lease only if the premises is rendered unfit to use as a result of either fire or flood, or an irresistible force which prevents him from using the property or which permanently destroys the property. So here again, under the statute in Section 108, the bar is very high. We are talking about something which in that sense is permanent in nature. And many a times you will see, of course, depending on the situation and the facts of the case, that a lockdown situation may not qualify for remedies under Section 108, because here it may be argued that the property is in that sense not destroyed by any irresistible force. It's a temporary event. So again, it's left to be seen as to how courts will look at this situation. And to give you an example, around a couple of weeks back, there was a case in Delhi concerning a shop in Khan Market. So here, the shop owner filed a petition before the Delhi High Court asking for suspension from payment of rent as a result of the lockdown. So the Delhi High Court looked at the contract and said that in this situation, had there been a force majeure clause which provided for suspension, of course we would have enforced that clause. But here, in this particular situation, there was no contract or a force majeure clause to be found. And therefore, the shop owner was not entitled to the remedy of suspension of payment of rent in terms of his particular contract. So, Delhi High Court also said to avail a remedy under 108, you will have to show on a case-by-case basis that the damage is permanent in nature, or it is some irresistible force which prevents you from occupying. So again, the bar is very, very high. However, having said that, the court exercised its equitable jurisdiction and came out with what they do these days quite a bit to balance interests, to come out with working solutions so that the interests of both parties are protected. However, these are all within the equity jurisdiction, and you cannot really treat it as law in that sense, as a precedent or a binding precedent for every case. It happens on a case-by-case basis. And talking of the rent situation again, we can always look at countries like Singapore or UK or Germany who have come out with their regulations which say that for a period of 3 months, no landlord will initiate any litigation for occupation of premises as a result of default on part of the licensee to pay rent. So that is again a welcome development. It gives open a lot of avenues for the landlord and the tenant to sit together, work out solutions, and try and come out with amicable solutions like suspension of rent for some time, reduction of rent, deferment of rent, so that the interests of both the parties are protected. You will also see governments like the Maharashtra government who has come out with an advisory that do not insist on payment of rent for a period of 3 months. But as you know, it's an advisory, does not have the force of law, and it's left to be seen on a case-by-case basis. So even going ahead in future, do consider in all your leave and license and lease agreements to include a force majeure clause so that if something unforeseen and grave like this pandemic happens in future, you can always take recourse to that contractual right and appropriate remedies can follow. Lastly, coming to the aspect of wages and payment of wages, which is also another interesting question which keeps coming up of whether an employer is bound to pay wages in this situation to employees. And here, you can look at initially on 20th of March, there was a notification by the Labor Ministry, which was in the form of an advisory, which said that employers were advised to continue to pay salary and the rent and the wages to employees during the lockdown. They should not deduct and they should not terminate the employment. But this was, of course, an advisory. Subsequently, on 29th March, under the Disaster Management Act, a notification was issued. This was in the context of migrant laborers. And it was said that employers should pay full salary, full wages, no deductions, and no termination of service. So this also had penal consequences which will follow if there was a violation of this notification. After this, after 29 March, we saw a number of state governments which came out with their own individual set of notifications on payment of wages, including the Maharashtra government, the UP government, the Delhi government. Some of these were in nature of advisories. Some of these were under the Disaster Management Act and had the force of law. Now the situation was unique where even employers were finding it very, very difficult to make payments of full wages because there was no business, there was no production activity, and there was no income. So a number of employers got together and filed cases before the High Courts as well as the Supreme Court, challenging these notifications. What initially the Supreme Court did was issue a notice to the government to answer as to how they plan to implement these notifications. Thereafter, there were orders passed which were in that sense pro-employer, where Supreme Court directed that no coercive steps will be taken against employers who are unable to pay or who are unable to comply with these notifications. After that, we saw that on 17th of May, when the lockdown was extended for the 4th time, the government passed the guidelines which said that the prior orders will cease to have effect from 17th May unless it was expressly extended, which meant that many of the orders, including the 29th March notification under the Disaster Management Act, had no longer any force, and in that sense, it was revoked from 17th of May. So then, what remained before the Supreme Court was twofold. One is what happens of this interim period between March 29th and May 18th, where the notification was in force and where employers were bound to pay. So here, the decision is still pending. And the second aspect is the challenge to the various state notifications, including the Maharashtra state notification, which is also alive. Unlike the central notification, it was not revoked. It is even alive today. However, it is sub judice and it is before the Supreme Court as well as various high courts, where these state government notifications are also under challenge. So this aspect about payment of wages is also something which is a dynamic situation. It is developing from time to time, and we will see in days to come as to what stand finally the Supreme Court takes on this aspect. But having said that, like any other issue, this issue can too be sorted by way of amicable settlement and discussions. Because today, out of all these issues are faced, the key to the solution lies in a composite compromise arrangement, an amicable solution where interests of all the parties are taken care of. So an employer and an employee can always work out solutions, mutually have an understanding, and keeping in mind each other's position, take decisions which are favorable and which cater to the interests of all the parties. As they say, litigation should always be the last resort because litigation is virtually a legal right which ensures that every corporation spends at least a decade in court. So you don't really want to invoke litigation at the first instance. That is an avoidable aspect. And as they say, that a bad compromise is much better than a very good looking lawsuit. So the need of the hour is to try and work out amicable solutions, be it contractual issues, labor issues, rent issues, or any other aspect that we are facing as a result of the COVID-19 pandemic. And one example which we can draw to is again looking at governments like Singapore. Singapore recently passed the COVID-19 Temporary Measures Act, which gives a 6-month moratorium on initiating any litigation in context or concerning construction contracts, tourism contracts, and various other contracts which were severely affected by the lockdown. So in this situation, no party can initiate any litigation to deal with these contracts for a period of 6 months, which gives enough time for parties to sit together and try and work out amicable solutions so that interests of both the parties and all the parties are balanced and you can come out with working solutions which are favorable to all. So therefore, this is also something which can be considered by the Indian government as we progress and as we have days to come. The government, of course, has been taking a number of steps, like we all know that, for instance, RBI has issued a moratorium on payment of loans initially for a period of 3 months, which was thereafter extended for a period of 6 months and is in force till August 31st, 2020. So we also have the IBC, the Insolvency and Bankruptcy Code, where there were talks that there will be a total suspension on initiating new proceedings for a period of 1 year. A notification to that extent is expected. The Supreme Court has also passed an order suspending the period of limitation for filing suits and proceedings, and the period of the lockdown in that sense will not be taken into account while computing the period of limitation. So there have been a lot of movement on regulatory measures by various regulators. SEBI has come out with comprehensive disclosure guidelines which require companies to make proper financial disclosures in connection with impact of the COVID-19 pandemic and the lockdown on the operations as well as the commercials of a company. The insurance regulator, the IRDA, has come out with clarifications and advisories. Particularly, there was an issue to do with non-occupancy clauses in insurance policies where the insurer would be absolved of his liability if a premises was not occupied for 30 days. So that has now been clarified that that clause will in that sense not be strictly implemented. And various other regulators have stepped in, clarifying, advising, giving out advisories so that there is clarity and certainty. Because in a legal jurisprudence, in a regulatory framework, what is very, very important is that there should be complete clarity in proceeding ahead. There should be transparency in the manner of functioning so that the wheels of the industry move forward smoothly and steadily. So I would like to end by saying that trade and commerce are like Indian rubber, and they will bounce back from any challenge which is thrown to them, be it a challenge in the nature of a regulatory change or a challenge in the nature of pandemic that we are facing today. Having said that, thank you all for a very patient hearing. I will be happy to take questions, and even otherwise, if you all have any questions, please feel free to email me whenever convenient.